Today we are discussing RA 8042. Section 2 outlines the state's policies. It upholds the dignity of its citizens and provides full protection to labor, local and overseas. Importantly, the state does not promote overseas employment as a means to sustain economic growth. The program exists solely if the fundamental human rights of Filipinos are not compromised. It also affirms gender equality and guarantees free access to courts. Under this law, uh, the Philippine government explicitly enshrines the principle of prioritizing the dignity and fundamental rights of its citizen over economic gains, refusing to trade people for profit. While the state openly recognizes the massive contribution that Filipino migrant workers make to the national economy through their foreign exchange remittances, it establishes a strict boundary. The state does not promote overseas employment as a means to sustain economic growth or achieve national development. Instead, the law dictates that the very existence of overseas employment program rests solely on one uncompromising condition: the assurance that the dignity and fundamental human rights and freedom of the Filipino citizen shall not at any time be compromised or violated. To reduce reliance on overseas work, the state commits to continuously create local employment opportunities and promote an equitable distribution of wealth. So how does this principle is enforced? The law provides clear mechanisms to ensure this declaration is not just an empty promise, putting human dignity and safety ahead of economic output. Restricted deployment. The state is mandated to deploy overseas Filipino workers only in countries where their rights are proven to be protected. The receiving country must guarantee this protection through existing labor laws, participation in multilateral conventions, bilateral agreements with the Philippines, or other positive concrete measures. Also, there's a power to ban deployment, reaffirming that public welfare overrides economic benefit. Section 5 grants the government the absolute right to terminate or impose a ban on the deployment of migrant workers at any time if the national interest or public welfare requires it. There is also skill-based protection, recognizing that skilled workers are generally less vulnerable to exploitation than unskilled labor. The state establishes a policy to eventually deploy and allow the deployment only of skilled Filipino workers as soon as practicable. By establishing these rules, the law makes it clear that no amount of remittance revenue is worth sacrificing the dignity, safety, and human rights of the Filipino citizen. Under Section 4 of RA 8042, the absolute legal prerequisite for the deployment of overseas Filipino workers is that the state shall deploy them only in countries where the rights of Filipino migrant workers are protected. To legally satisfy this prerequisite, the receiving country must provide a recognized guarantee of protection by meeting at least one of the following criteria. It has an existing labor and social laws to protect the rights of migrant workers. It is a signatory to multilateral conventions, declarations, or resolutions relating to the protection of migrant workers. It has a concluded in a bilateral agreement or arrangement with the Philippines, specifically protecting the rights of overseas Filipino workers. It is taking positive concrete measures to protect the rights of migrant workers. And furthermore, as long-term prerequisite regarding the workers themselves, the law establishes that as soon as practicable, the government shall deploy or allow the deployment only of skilled Filipino workers, recognizing that the possession of skills serves as the ultimate protection of migrant workers. Now we go to Section 6 of RA 8042. The definition of illegal recruitment goes far beyond simply operating without a license or authority. While the law naturally penalizes unlicensed individuals who recruit or promise overseas employment, it establishes a strict net of accountability that also catches legitimate licensed agencies if they engage in abusive practices. The law dictates that the following acts constitute illegal recruitment, regardless of whether the offender holds a valid government license or not. Financial exploitation, overcharging, charging or accepting any amount greater than the allowable fees prescribed by the Secretary of Labor and Employment. Loan fraud, forcing a worker to pay back an amount greater than the loan or advance they actually received. Withholding documents, holding a worker's travel documents hostage before departure to extract unauthorized monetary or financial payments. Failure to reimburse, refusing to reimburse a worker's documentation and processing expenses if their deployment fails to push through without any fault of their own. Deception and misrepresentation, false information, publishing or furnishing any false notices, information, or documents related to recruitment or employment. License fraud, using false testimonies or committing misrepresentation just to secure recruitment license or authority. Contract alteration, substituting or altering duly approved employment contracts to the prejudice of the worker without securing the necessary duly approval. Harmful and anti-competitive practices in poaching workers, including a worker who is already employed to quit their job to offer them another unless it is specifically to free the worker from oppressive conditions. Blacklisting, influencing or attempting to influence any person or entity not to hire a worker simply because they did not apply through the recruiter's agency. Harmful jobs, recruiting workers for jobs that are harmful to public health, morality, or the dignity of the Republic of the Philippines. Regulatory defiance, obstructing inspection, attempting to block or obstruct inspection conducted by the Secretary of Labor and Employment, reporting failures, failing to submit required reports regarding employment status, placement vacancies, foreign exchange remittances, and worker departure. Uh, Next would be the failure to deploy, failing to actively deploy a recruited worker without a valid reason as determined by the DOLE, and conflict of interest for the officer or the agent of a recruitment agency to also become an officer, board member, or manager of a travel agency. And the escalation of economic sabotage. If any of these acts, whether committed by a licensed or unlicensed entity, are carried out by a syndicate, three or more persons conspiring together, or in large scale committed against three or more persons, the violation is elevated to an offense involving economic sabotage. This triggers the law's most severe penalties, punishable by life imprisonment and a fine of up to 1 million pesos. Under 8042, the standard crime of illegal recruitment reaches a legal tipping point and is elevated to the devastating offense of economic sabotage when it meets specific numeric thresholds regarding either the perpetrators or the victims. The law defines two distinct tipping points that trigger this severe escalation. One, the syndicate tipping point, focus on perpetrators. Illegal recruitment becomes economic sabotage if it is carried out by a syndicate. The law strictly defines a syndicate as a group of three or more persons conspiring or confederating with one another to commit an illegal act. This provision targets the organized systemic nature of exploitation, recognizing that groups operating together pose a significant higher threat to the public. Number two, the the lar- the large scale tipping point focuses on the victims. Even if the single recruiter acts alone without a syndicate, the offense is still elevated to economic sabotage if it is committed in large scale. This tipping point is reached the moment the illegal recruitment is committed against three or more persons, whether they are targeted individually or as a collective group. This ensures that recruiters who victimize a high volume of people face maximum accountability. The drastic shift in penalties crossing either of these tipping points fundamentally changes the legal consequences. A standard conviction for illegal recruitment carries a, a prison sentence of 6 to 12 years and a fine is 200,000 to 500,000 pesos. However, once the act crosses the threshold into economic sabotage, the state unleashes its maximum penalty. The offender face mandatory life imprisonment and face a fine ranging from 500,000 to 1 million pesos. Now we discuss the penalties under 8042. The principle of joint and solidary liability, also referred to as a joint and several liability, is a powerful mechanism designed to guarantee that an overseas Filipino worker can actually recover monetary claims or damages if they are wronged or the contract is violated. Here is how this liability mechanism protects the worker. Tying the local agency to the foreign employer. The law dictates that the liability of the foreign principal employer and the local recruitment or placement agency shall be adjoined and several for any and all claims arising from employment relationship or contract. This is crucial because this means a wronged worker does not have to navigate foreign legal systems to chase an employer abroad. They can demand the full payment of their claims directly from the local recruitment agency here in the Philippines. To ensure this is enforced, this joint liability provisions must be explicitly written into the overseas employment contract as a strict condition before the government will even approve the deployment. Furthermore, the deployment bond filed by the recruitment agency is legally designed to answer all these money claims and damages. Next would be piercing the corporate veil. Again, much like the criminal trapdoors we discussed regarding BP 22 and the trust receipts law, RA 8042 pierces the corporate shield, but this time for civil financial liability. If the recruitment or placement agency is a corporation or partnership, the law states that the corporate officers, directors, and partners shall themselves be jointly and solidarily liable with the company for the workers' claims and damages. This prevents agency owners from hiding behind the bankrupt corporate entity to avoid paying distressed workers. Next would be the indestructibility of the liability. Finally, the law ensures that this joint and solidary liability is practically ironclad. These liabilities continue for the entire duration of the employment contract. More importantly, this legal protection cannot be erased or affected by any substitution, amendment, or modification made to the employment contract, whether the change is forced upon the worker locally or after they have already arrived in the foreign country. Under Section 15 of RA 8042, the law establishes a strict waterfall or hierarchy of financial and logistical responsibility to ensure that the distressed or deceased overseas Filipino worker is always brought home. This repatriation waterfall flows through the following stages. First, primary responsibility, the local agency and foreign principal. The very first line of accountability rests on the private recruiters. The primary responsibility for repatriating the worker, as well as transporting their personal belongings or their remains if they are deceased, falls squarely on the local agency that recruited or deployed them. All costs associated with this repatriation must be strictly be borne by or charged to the local agency or its foreign principal. Number two, emergency interventions. The OWA, uh, the if the host country falls into a crisis such as a war, epidemic, natural or man-made disaster, or other similar calamities, the Overseas Workers Welfare Administration (OWA) immediately steps in to physically undertake the rescue and repatriation of workers. However, the financial burden remains at the top waterfall. OWA conducts this emergency rescue without prejudice to demanding full reimbursement from the responsible principal or local agency afterwards. Third, there's an ultimate financial fallback, the state via OWA. The waterfall reaches its final destination when accountability cannot be traced. If the principal or recruitment agency simply cannot be identified, all costs attendant to the repatriation shall be entirely be borne by the OWA. To guarantee the government always has the money to fulfill this ultimate safety net, the law mandates the creation of an initial 100 billion peso emergency repatriation fund. The absolute exception, the worker's fault. The law provides one major scenario where this liability waterfall does not apply to the recruiter. If the worker's termination of employment is due solely to the fault of the worker themselves, the principal and the local agency are completely absolved from the responsibility of funding the repatriation of the worker and their belongings. Also under RA 8042, the government establishes comprehensive data and advisory radar designed to proactively monitor the global conditions, track vulnerable citizens, and broadcast early warnings to prevent exploitation before a worker even leaves the country. This radar operates through two distinct but interconnected mechanisms: an outward-facing advisory broadcast and an inward-facing shared intelligence network. The Early Warning System Travel Advisories, Section 14 of the law, mandates the creation of a public warning system to prevent illegal recruitment, fraud, and abuse. The Philippine embassies and consular offices acting through the Philippine Overseas Employment Administration (POEA) are legally required to issue travel advisories and disseminate hard facts regarding labor conditions and migration realities in foreign nations. Crucially, this system evaluates and broadcasts whether particular countries actually adhere to international standards on human and workers' rights. The goal is to adequately prepare Filipinos to make informed, intelligent decisions about where they are going. To ensure this warning system reaches the public, these advisories must be published in a newspaper of general circulation at least 3 times every quarter. So the internal intelligence network shared government data to power these advisories and keep a watchful eye on deployed workers. Section 20 establishes a massive internal data engine, the Shared Government Information System for migration. The law recognizes that protecting a worker is impossible if government agencies silo their information. Therefore, an interagency committee spanning the Department of Foreign Affairs, Labor, Tourism, Justice, and various bureaus like Immigration and the NBI is strictly mandated to link their computer facilities and allow the free flow of data. This committee is required to declassify and share critical databases, creating a comprehensive radar that tracks master list of workers, detailed list of deployed workers, categorized by job, civil status, and visa classifications, alongside list of departing and arriving Filipinos. Legal entanglements, an inventory of pending legal cases involving Filipinos abroad, explicitly including those who are serving prison terms. Threat assessment, list of blacklisted or undesirable foreigners, as well as basic data on criminal codes, marriage laws, and immigration policies of receiving countries. Next would be gender specific tracking, as a specialized tracking system dedicated to monitoring past and present cases involving both male and female migrant workers, ensuring gender specific vulnerabilities are closely monitored by fusing mandatory public advisories with this heavily integrated government data network. RA 8042 ensures that the state is not just reacting to crises but actively mapping the global landscape to steer worker away from danger. So to continue, the state guarantees the round-the-clock protection and support for workers deployed abroad through an establishment of migrant workers in overseas Filipino resource center. Look, location and continuous operation. These resource centers are strictly mandated to be established within the premises and under the administrative jurisdiction of the Philippine Embassy in countries that host large concentrations of Filipino migrant workers. To ensure that distressed Filipinos are never left without a lifeline, the law explicitly dictates that these centers must remain open for 24 hours daily, including Saturdays and Sundays and holidays. To complete this continuous network of communication, the law also mandates that the center must have a counterpart 24-hour information and assistance center located back at the Department of Foreign Affairs. So, comprehensive support services. The resource center serves as a comprehensive sanctuary and operational hub required by law to provide the following crucial services. First, emergency and legal aid. The center provides direct counseling, legal services, and welfare assistance, which explicitly includes procuring medical and hospitalization services for workers in need. Next would be social integration and training. It runs programs to help workers adjust, such as post arrival orientation, community networking, and human resource development, like skills upgrading. It also features gender sensitive programs, specifically designed to assist with the particular needs and vulnerabilities of women migrant workers. Next would be active monitoring. Staff are required to monitor the daily situations, circumstances, and activities affecting overseas Filipinos in host country. Next would be capturing undocumented workers. The center institutes a registration scheme specifically to bring undocumented workers under the protective purview of the Act. It compels undocumented workers to register with the center within 6 months under the threat of having their passport cancelled. If they refuse, staffing and highly problematic mandate, the center is a joint undertaking of various government agencies and is coordinated by the labor attaché. It is meant to be staffed by a collaborative team of foreign service personnel, service attachés representing different Filipino agencies when available, individual volunteers, and legitimate non-government organizations from the host country. Crucially, the law establishes a specific fail-safe for dangerous deployments. If the host country is categorized as highly problematic by the Department of Foreign Affairs and the Department of Labor and Employment, The government is strictly mandated to provide dedicated lawyers and social workers to staff the center and protect the concentrated population of Filipino workers there. Furthermore, the state institutionalizes legal defense for migrant workers by fundamentally declaring that poverty must never prevent a person from having free access to the courts and adequate legal assistance. To turn this principle into reality, the law establishes a comprehensive, well funded legal infrastructure dedicated entirely to defending overseas Filipinos in distress. This institutionalized defense operates through several powerful mechanisms. The Legal Assistant to Migrant Workers Affairs. The law creates a powerful new position within the Department of Foreign Affairs, holding the rank of salary privilege equal to that of an undersecretary. This official serves as the primary coordinator for all legal assistance services provided to Filipino migrant workers. To ensure an effective defense strategy, the legal assistant has the explicit authority to hire private domestic or foreign lawyers to assist in discharging these duties. Furthermore, they are mandated to actively tap assistance of reputable law firms, the IBP, and other bar associations to complement the government's efforts. The 100 million peso legal assistance fund to guarantee this defense system is financially empowered. The law establishes a 100 million peso legal assistance fund. This massive financial pool is strictly used exclusively to provide legal service to distressed migrant workers. Crucially, it pays for the heavy cost of navigating foreign legal systems, explicitly including fees for foreign lawyers representing workers facing charges abroad, bail bonds to secure workers' temporary release from detention, and other court and litigation expenses. Free legal aid for victims of illegal recruitment. Domestically, the law mandates the Department of Labor to establish a specific mechanism to provide free legal assistance for victims of illegal recruitment. This local defense network operates in coordination with the Department of Justice, the IBP, and the volunteer non-government organizations. Pursuing international redress, the defense system also extends the International Tribunal. The Department of Foreign Affairs is tasked to assessing the avenues of redress under international and regional human rights systems. If it is legally impossible for an abused migrant worker to file an individual complaint themselves, the state is mandated to step in and pursue the case on the victim's behalf through the legal assistant by creating a dedicated undersecretary level defender, backing them with a massive litigation fund, and providing mechanism to hire private foreign counsels. RA 8042 ensures that distressed Filipino workers are equipped with an institutionalized legal shield regardless of where they are in the world. Under this act, the country team approach is the legal mandated operational structure for Philippine embassies and foreign posts, designated designed to ensure the government operates with a single unified front to protect Filipinos. Here is how this unified strategy operates. One mission under unified leadership. To eliminate bureaucratic infighting in these organized responses, the law dictates that all officers, representatives, and personnel of the Philippine government posted abroad must act as one country team under the direct leadership of the ambassador. Crucially, this applies regardless of the personnel's original mother agencies back home, such as DOLE, OWA, or DFA. If there are Philippine consulates in the host country, they are also strictly integrated into this single team under the ambassador's command. Furthermore, any visiting Philippine delegation must be provided with full support and information in line with this approach. The highest priority concern: this unified team is not deployed merely for diplomatic formalities. The law explicitly declares that the protection and promotion of the welfare of the Filipino migrant workers, along with upholding their dignity and fundamental rights, shall be the highest priority concerns of the Philippine Foreign Service post in the Secretary of Foreign Affairs. Enforcement and accountability. To ensure this approach is strictly followed, the law grants the ambassador significant disciplinary authority over the entire team if any officer or representative commits acts contrary to the national interest, specifically including the failure to provide the necessary services to protect the rights of the Filipinos. The ambassador has the power to recommend their immediate recall. To enforce accountability without delay, the ambassador is also empowered to place the offending personnel under preventive suspension while waiting for the appropriate body in the Philippines to investigate the recommendation for recall. So, to continue, the state recognizes that an overseas deployment program cannot be a permanent solution for national development. To systematically bring workers home and ensure their sacrifices yield long-term benefits, the law establishes a comprehensive infrastructure for economic reintegration and generational educational legacy. The engine of the integration. The replacement and monitoring center to provide restructured mechanisms for returning overseas Filipino workers to smoothly re-enter Philippine society. The law mandates the creation of replacement and monitoring center within the Department of Labor. The center acts as a promotion house for local employment designed to harness the skills and potential the workers have acquired abroad and redirect them towards national development. The center is tasked with several crucial functions to secure the returning workers' financial future. First, livelihood and job matching. It is legally mandated to develop livelihood programs in coordination with the private sector and conduct periodic assessment of local job opportunities. Furthermore, it must institute a computer-based information system of skilled returning workers to connect them directly with both public and private local employers, promoting productive investment. The DOLE, alongside with OWA and POEA, must implement programs that actively motivate returning workers to pursue productive options. This includes guiding them to transition into highly technical jobs, develop entrepreneurial ventures, and make smart investments with their foreign savings. Next would be prioritizing vulnerable sectors. The law ensures that those who face the highest risk abroad receive the most help at home. Government agencies involved in training and livelihood development, such as the Technical Education and Skills Development Authority, TESDA, and the Technology Livelihood Resource Center, TLRC, are strictly mandated to give priority returnees who were employed as domestic helpers and entertainers. Next would be educational legacy. The Congressional Migrant Workers Scholarship Fund beyond immediate economic reintegration. RA 8042 establishes a lasting generational reward through the creation of the Congressional Migrant Workers Scholarship Fund, recognizing that the ultimate goal of many migrant workers is to secure a better future for their children. This fund is strictly designed to benefit deserving migrant workers and their immediate descendants who are under 21 years of age, to strategically build the country's capabilities. This scholarship is is specifically tailored for those who intend to pursue courses or training primarily in the field of science and technology. To guarantee this educational legacy is heavily supported, the law established an initial fund of 200 million pesos sourced from government development funds and lotto draw proceeds. Administered jointly by the DOLE and the DOST, this fund ensures that the financial sacrifices made by migrant workers directly translate into an advanced high level educational opportunities for the next generation. So we go to our last slide. So RA 8042 constructs a comprehensive protection continuum that safeguards Filipino migrant workers at every stage of their overseas journey. From the moment they consider working abroad to their eventual reintegration into the Philippine society. This continuum operates through five distinct phases of intervention. First, the pre-deployment shield. The continuum begins before a worker even leaves the country. The state enforces a strict prerequisite. Workers can only be deployed to countries that legally guarantees the protection of their rights through existing laws, multilateral conventions, or bilateral agreements. To empower workers to make informed decisions, the government operates an early warning system through mandatory travel advisories, detailing labor conditions and migration realities in foreign nations. Furthermore, to protect workers from predators at home, the law established strict definitions for illegal recruitment and elevates large-scale or syndicated offense economic sabotage, punishing them with life imprisonment. Number two would be the contractual anchor. To ensure the workers are not left chasing phantom employers in foreign jurisdiction, the law weaves an unbreakable financial safety net into their contracts. It mandates joint and several liability between the foreign employer and the local recruitment agency. This guarantees that if a worker is abused or unpaid, they can demand their full monetary claims, damages directly from the local agency here in the Philippines. Number three, the on-site sanctuary 24/7 protection, unified actions. While abroad, the continuum provides physical and legal sanctuary. Workers are protected by the Migrant Workers and Overseas Filipino Resource Center, which is strictly 24/7, including weekends and holidays, to provide emergency counseling, medical procurement, and legal services. This physical hub is backed by the country team approach, where all Philippine government personnel acts as a single unified mission under the ambassador. So if a worker faced legal trouble, they are shielded by the institutionalized legal defense, spearheaded by an undersecretary level legal assistant for migrant workers affairs and backed by a 100 million peso legal assistance fund to hire foreign counsels and pay bail bonds. Number four is the rescue mechanism. If deployment fails or crisis erupts, the continuum activates a strict hierarchy of rescue. The primary responsibility and financial burden for repatriating the workers falls entirely on the local recruitment agency and the foreign principal. In emergency scenarios like war, epidemic, or natural disasters, the OWA immediately steps in to fund and execute the rescue, ensuring workers are brought home regardless of the recruitment agency's immediate capacity. Fifth would be the reintegration phase. The final stage of the continuum ensures the worker's safe and productive return. The replacement and monitoring center serves as a promotion to harness their acquired skills for local employment, livelihood projects, and entrepreneurial developments. Ultimately, the continuum secures a generational reward for the workers' sacrifices by establishing the Congressional Migrant Workers Scholarship Fund. A 200 million peso initiative specifically ensuring that the immediate descendants of the migrant workers can pursue higher education in the field of science and technology. So, thank you very much for listening and attending this session. This ends our presentation for RA 8042.